Hey, it's Brandon with Myers Realty, your local real estate agent here in Delaware. Today, I'm super excited. I'm going to bring you guys a video with a local attorney here, Adam Gerber, who specializes in probate and estate planning, just to tell you a little bit more about the process itself. Um, and yeah.
Good morning, everyone. My name is Adam Gerber, like Brandon said. I'm a partner here at Wolfe Associates. We are a real estate firm. We also do estate planning and probate, and those are my areas of practice specifically. So I'd like to answer some of your questions today about the probate process.
So what I like to do is just go over, I guess, an overview of the actual probate process here, in Delaware, and then just ask some, some commonly asked questions that I've heard people having when actually taking them through the probate process when it comes to, real estate.
Sure. Why don't I start with just a basic overview of probate, what it is? So probably a lot of people have heard the term probate. Here we call it the probate office or the Register of Wills office. And the Register of Wills office is the office that oversees basically the administration of someone's estate. So if someone dies, whatever they own at the time of death is their quote unquote estate. So whatever assets they own at the time of the death is their estate, and those assets have to be distributed out to someone, to their heirs. So the probate process is the process by which those assets are distributed out to the beneficiaries or heirs. That process here in Delaware usually takes about 9 months to a year or so. And as I said, it's overseen by the probate office or Register of Wills office.
Okay. And as far as the person who's in charge of all that, is that set? Is that set beforehand or?
So it can be. So the person in charge of distributing the assets is called the executor or personal representative. So that we'll just call them executor today for the purposes of this discussion, but the executor is the person in charge of distributing out the assets and basically managing the business affairs of the estate once a person has died. So if someone has a will that specifies who the executor is, then yes, that is set. Now, if someone dies without a will, then the executor would not be set, and basically the next of kin can file a request with the Register of Wills office to be appointed as the executor.
Okay. And if there's multiple people involved, then they would all go or they would.
And that's a good point, because that can cause some confusion, sometimes even conflict, because if you have not specified exactly who the executor is in your will, then if, for example, you die and you have three siblings, they could each be eligible to be the executor, and they could all be executor together, or there could be conflict, like I said, if one of them wanted to be executor and didn't want the others to be executor. So it's probably best to name someone specifically,
Okay.
but if one is not named, then the whole class, we call it, but basically the people who are next of kin all have the ability to serve as executor.
I guess one of the common questions is I know you said 6 to 9 months usually. Is that on average on how long it takes to get through the whole probate process? Um,
So 9 months or so is about the average. Sometimes it takes closer to a year, but the real reason it takes that long is because there's something called a creditor claims period.
okay.
So when someone dies, their creditors, let's say they owed money to a credit card company or some other debt, their creditors can file a claim against the estate to try to recover on that debt. And the creditors have 8 months from date of death to do that. So we have to leave the probate estate open for at least 8 months to give those creditors an opportunity to file those claims. So then after that, it takes a month or two probably to close out the estate, file all the paperwork that needs to be filed to close out the estate, including a final accounting showing everything that was in the estate. And then you can deduct off some of the expenses, like administrative expenses, attorney fees, and debts paid. And then once you file that final paperwork, you can close out the estate and distribute the funds.
Okay. So from more so, like I said, is more so geared towards real estate.
Sure.
So from a real estate transaction, you have the ability to actually sell the property, but the proceeds wouldn't be dispensed until after that creditor's claim or after that was all cleaned up, correct?
Yeah, good question. And that's where I see real estate and this probate process kind of interacting the most. You're exactly right. So just for clarity, yes, if somebody inherits property through a will or through an estate, if there is no will, if they inherit the property, they can still sell that property before that 8 month creditor claims period is up, but those proceeds would have to be held in an escrow account until that claims period has expired.
Okay.
The reason being that let's say there was a creditor that filed, basically at the 11th hour, filed a claim, a rather large claim, let's say. The proceeds from the house have to be kept in an account in case there's a creditor that files late or any time during the 8 months, so that we have enough money to pay that creditor back.
And for all intents and purposes, from the 8 months, is that from date of death or from when the estate is open?
That is technically from date of death.
Okay.
It is. So the idea being that if a creditor found out about someone's death, even if the executor didn't open up the estate, the creditor actually kind of has the obligation to open the estate, get that open so they can file a claim against the estate. But that's what the law says, 8 months from date of death.
Okay.
Yeah.
So, I mean, that makes a lot of sense. I know sometimes when you're going through a passing of a loved one, the first thing on their mind isn't, hey, opening my estate.
No,
So,
exactly.
So that was the reason for that.
Of course not.
So does probate still happen if you do have a will, like an estate and a will done already? So I have a living will or a will of some sort. I pass away unexpectedly. Does that process does my, assets still have to go through probate?
Yeah, great question. So yes. So probate, as I kind of mentioned at the outset, probate is the process by which the probate office or register of wills office here oversees the distribution of assets covered by the will. So the will says who gets those assets, but the probate office is overseeing that through the probate process. So yeah, even if you have a will, and I think this is a common misconception, even if you have a will, those assets still have to go through that whole probate process, pay the fees that are associated with that, and wait that usually 9 months to a year or so.
Okay.
The only way to keep assets out of probate, well, there are two main ways to keep assets out of the probate process are by naming beneficiaries on whatever accounts you could name it. So let's say you have an investment account. If you name a beneficiary, or for example have like a life insurance policy with a beneficiary, those assets will go directly to the beneficiaries and not have to go through the probate process. So that's one main way to avoid probate. The other way is to set up a trust, usually a revocable living trust, put assets into that trust, and then any assets in that trust at your death won't have to go through probate either. So those are the two ways we can avoid probate. And that's actually what I do for a lot of my clients is I help them plan in advance so their loved ones don't have to go through that probate process and pay all the fees that are associated with it.
Okay. Yeah, because I was going to get into that. You got me beforehand. For all my investors out there, I know there's people who have multiple rental properties and things like that. I mean, more than likely, they would probably want to, put that in a trust so you don't have to go through that. And is it true that like the assets in the trust are kind of like not disclosed or something?
Well, yes,
Or
in a
not
sense.
public
No,
record?
you're right. They're not public record, and so there is some confidentiality there. Yeah, exactly. Whenever someone dies, their will has to be filed with the Register of Wills office, with that probate office we keep talking about, and that does become a part of the public record. But if you have a trust that's not filed with the probate office, all the will really says is that any assets in your that are not, excuse me, in your trust at your time of death will be transferred to your trust after your death. But the trust is never filed with the Register of Wills office, meaning that the terms of the trust, in other words, who gets what, is never disclosed, never becomes part of the public record. So that's a nice kind of side benefit of having a trust. Yeah.
Okay. And I guess for probate, if you're in a marriage, or however, if you're in a marriage, if one of the spouses were to pass away, does the property just directly transfer into the other surviving spouse?
Good point. Yes. Frankly, I should have mentioned this earlier. If, as I was talking about earlier, having a beneficiary designated, if you own property jointly with someone, then that property will pass to the joint owner if they survive you. So with a husband and wife, as long as the deed is specified a certain way, as I'm sure you see a lot in your business, but as long as the deed is correctly worded, then yes, the property should pass to the surviving spouse.
And is that without the probate process? Will they still have to open an estate for the deceased, or?
Well, possibly not.
Okay.
In other words, if your assets all pass to your spouse, or most of your assets, let's say, then you might be able to file what's called a small estate affidavit, and possibly in conjunction with a jointly held affidavit. in other words, certifying that you held this property jointly with someone.
Scaring me with all those. We're getting into it.
There's a surprising amount of paperwork that goes through all this. But here's the rule of thumb. Right now, the way the law states that if you have less than $30,000 of assets in your sole name, and if you don't own any real estate in your sole name, then your spouse, your loved ones, whoever's filing the estate documents for you, they can just file a small estate affidavit certifying that you didn't have more than $30,000, you didn't own any real estate in your sole name, and then they just file that one-page affidavit, and that takes care of the estate. So that essentially avoids the whole probate process.
Okay.
So that's really the goal for most of my clients, is to set things up so that your loved ones have a much easier, much less expensive process to go through at your death.
Just piggybacking off of that question, so I don't know why anybody would want to, but if you didn't have an attorney to handle the probate process, can you do it yourself?
Yeah, you can do it yourself. Yep. A lot of what I help clients with is especially of out-of-state executors.
Okay.
So if you do want to handle probate on your own, then you have to schedule an appointment with the Register of Wills office and go in and bring all your papers with you, and they'll meet with you in person and get everything set up. And they'll help you through that.
And
that's
state
fine.
Service, right?
What's that?
And that's a state service.
Yes,
right?
that's state. That's right. You're going over the state building. Yeah, you
so
deal with all that.
Fun.
And they're very nice and helpful. But a lot of the time, whenever we have an executor who lives out of state, the way I can really help them is that I can help them avoid those in-person meetings and flying back to Delaware, frankly. I can file all the documents electronically. So we can handle all that by email, fax, whatever they need to get the documents filed. So I can draft the necessary documents, have them file it, and then, have them sign it, and then I'll file it for them.
Okay. And I mean, for all this, I know we can't really get into specifics because each individual, process is a little bit different depending on assets and everything.
Sure.
But just on an average cost, like let's say on a very simple, estate, there's just a one heir, maybe a house, and that's it. I mean, as far as costs go,
sure.
What do you look at? Is it a very expensive process, or
it's not extraordinarily expensive? So my fees, we'll start there.
That's right.
I charge hourly just because if it is a simpler probate, then I don't have to charge as much because I spend less time. But if it gets more complicated, then it will take a little bit more in attorney's fees. Yeah. But I have found that on average, right now as of the recording of this, the fees are around $1,500 to $2,000, maybe up to $2,500 or so. But it's, let's say, around $2,000 or so in attorney fees.
Okay.
Now, on top of that, though, are filing fees. There's some administrative fees due to the probate office. And then one of the bigger fees potentially is that whenever you probate an estate, you have to pay, at least in Newcastle County, I think it's a little lower in Sussex County, but you have to pay a 1.75% probate fee, kind of like a probate tax, but it's called a probate fee, on the net assets of the estate. Okay. So that's really one of the major expenses we're trying to avoid. We're trying to keep assets out of your estate by, as I said before, either having a beneficiary designated, jointly owning property, or putting them in a trust, so that those assets aren't subject to that probate fee.
Sure. So, I mean, I guess that kind of just pulls me right into my next question would be, what are some things that we can take in order to actually, what's the tax burden when it comes through, probate? Like if I inherit a property and I make $200,000, do I have to pay my regular, 22 or 33% on the profits made?
Right. Good question. So right now, I'm just talking about Delaware, of course. Right now, Delaware doesn't have an inheritance tax or estate tax. Okay. Now there is an estate tax federally, but the limits are very high right now. We don't worry about it too much, but it's still a factor we want to talk through. But to your point, I want to focus mostly on the capital gains. I think that's kind of what you're talking about. So in other words, if your parents owned a house and they bought it at, let's say, for $100,000 20 years ago, now it's worth $300,000. Sure. Well, if both parents are deceased and you inherit the property, the value of the property, let's say at their date of death, was $300,000. Sure. Well, normally there would be what's called capital gains tax, meaning that you have to pay a tax on the gain or the increase in value of the home. So here we have $200,000 of capital gain, meaning the difference between what they bought it at, $100,000, and the value at their date of death of $300,000, just in this hypothetical. Yeah. So normally you would have to pay tax on that, but there's a special exemption, kind of almost a loophole, which states that if you inherit a property, you get to use for your tax basis the date of death value from whenever you inherited the property. So really what happens is that for all intents and purposes that capital gain disappears. So you are not responsible paying that capital gains on the increase in value if you inherit the property through a will.
Okay.
Now you have to be careful about how the will is worded because there is some potential wording that could bring the value of the home back into the probatable estate and be subject to that probate fee. But if we word the will correctly, you should be able to inherit the property using that what's called stepped up basis,
Okay.
and you get to avoid paying that capital gains tax.
Okay. So, I mean, that's good to know because I think a lot of people may think, if we're talking 20, 30 years down the line and I inherited my parents' house and they don't owe a mortgage at all.
Yeah.
It wasn't my primary residence, so I don't get that, that
Right. Yeah. And this is different from the primary residence exclusion.
So
Yes.
I don't get that exclusion. So it's just like, okay, I just made, $250,000.
Yes.
Do I have to pay, tax on this? Because if that's the case, I don't want to sell the house.
Right. Right. No. Good point, and I'm sure that's a common concern. And no, generally not. That stepped up basis. That's really kind of the key term to keep in mind. So yeah, that's right. That's really a huge tax advantage
Correct.
to inheriting property, because I do have a lot of clients who come to me and they want to just transfer their property to their children, let's say during their lifetime, and I get it, that makes some sense.
Sure.
But honestly, there are two main drawbacks I see with that. Then I just warn clients of. The one is potentially losing that stepped up basis, right? So that's something you got to think about. And then also, if you transfer your home to your children during your lifetime, what if they got a judgment against them?
Correct.
So let's say they were in an accident or something and somebody got a judgment against your child who now owns this property. Well, that judgment creditor could pursue a claim against the house, which is now your child's house technically. So just a couple things to think about before transferring property during your lifetime.
Yeah, and then if we do it early enough and the property appreciates in value, they're going to take that. They're going to take it from when you inherited the property, right?
Yeah, exactly.
When you
purchased the property, right? They would basically take over your tax basis. So right, that's the real risk. If they gift you the property, then you're taking over their tax basis. You're not, in other words, getting to take advantage of that stepped up basis. In other words, the date of death values. You're going to be paying capital gains unnecessarily, probably.
Yeah. So yeah, we definitely don't want to do that.
No.
So and I guess I know, like I said, the whole concept itself, with death, probate, everything is a little uncomfortable. So, I mean, what exactly happens because we see a lot of single parent,
Sure.
single moms, single fathers, what it may be, and underage children, when that happens and there's not, the parent unexpectedly passes away or whatever, and the inheriting child is, I'm sorry,
Is a minor.
Yeah, so the child is a minor. How exactly does that work with because there is no other person? Would it be like the beneficiary, or if you haven't set up a will or don't have any type of directives of who should be taking care of this, how exactly does that work?
Right, and that's why I do strongly recommend everybody have a will. I mean,
Sure.
People think, well, I don't have too much, do I really need a will? But yeah, I mean, if you have any assets, any family, especially small children, like minor children, you want a will, because a will can address that in two ways. So in your scenario, let's say someone dies and there is not a surviving parent.
Correct.
Well, then the next of kin would probably be the first ones in line to be guardians of the minor children, but they'd have to go to court to be appointed as guardians. And again, that leaves some confusion, potential arguments if nobody is specified in your will.
Yeah.
So in your will, you can do two things. You can specify who you would like to be guardian. Now, the court is still going to have the final say on who is named the legal guardian, but probably the court would follow your wishes unless there's some compelling reason not to.
Yeah.
But what you can do very definitively in your will is you can name someone to be the trustee over the assets that you leave for your minor children.
Okay.
So in other words, we can do it a couple different ways, either setting up a trust during your life or building in something called a testamentary trust, which is a trust built into your last will and testament. That's why it's called the testamentary trust. And that language will specify who you want to be the trustee after your death, or if you become incapacitated, to manage the assets for your kids.
Okay.
So we have two things going on here. We have who has physical guardianship or custody over the children, and then who's managing the assets for the children.
Okay.
Could be the same person, but doesn't have to.
One thing specifically in my business when we're going through the probate process is that we have to get documents signed, for listing agreements and everything of that nature. So who exactly has the authority to sign if there is no, will or if there's multiple heirs?
Great question. This does come up a lot. So that's one of the areas where I feel like real estate and probate really do intersect. The bottom line is that in most cases, the heirs are the ones who are going to be signing the listing agreement and all the sales documents, including the deed, the closing. There's one exception. That is if the will itself specifies that the executor is directed to sell the property. In that case, and really only that case, the executor then is the one who's going to be signing the documents. Okay. So they're going to sign the listing agreement. They're going to sign, like, the contract of sale and the deed, all the documents for the closing. But in most cases, it's going to be the heirs. In other words, whoever has inherited the property. And that's the same whether it's inherited through a will or without a will, through what's called the intestacy laws, meaning the person did not have a last will and testament. There are laws called intestacy laws that govern what happens with the property and other assets, just kind of as a default.
So basically, I mean, for us as, real estate professionals, we just want to make sure if there's three heirs that we're getting all three heirs signing something, unless
that's always the safest.
Yeah, unless they can get you a will or something that directly states like this person is the executor, this is the person taking care of all.
And so I get that question a lot, and I'm happy to look at it. If you wanted to send me, for example, a copy of the will, I can look at that and say whether or not I think there's language in there that would allow just the executor to sign, but most times it's going to be all the heirs, and that's the safest procedure.
Yeah, just to get everybody to sign. Well, it makes a lot of sense. So we talked a lot about wills and estate planning and everything like that. So if I do have a will in place, do I still have to go through the probate process?
Yeah, good question. In general, yes. Okay. So even with a will or without a will, something needs to be filed with the probate office.
Sure.
So if you have a will, you file that will with the probate office, and they oversee the distribution of the assets that are covered by the will.
Okay.
So even with a will, you do have to go through the probate process, because the job of the probate office or the Register of Wills office is to oversee the administration of your estate, meaning paying debts and then eventually distributing assets out from the estate.
Okay.
The only way to avoid probate is to keep assets out of your quote unquote estate. So estate means the assets that you own in your sole name at your time of death.
Okay.
So there are a couple ways that we can avoid having assets go into your estate.
Okay.
There are a couple relatively easy and cheap ways to transfer assets after your death outside of probate.
Okay.
Two main ways to do that are either holding property jointly. For example, if you own your house with your spouse, if you die before your spouse, as long as the deed is worded correctly, that property should transfer directly to your spouse and not go through probate. Sure. Importantly, not go through probate. Or the other way is to designate assets or designate beneficiaries for various assets. So let's say, for example, you have an investment account. You can designate a beneficiary or beneficiaries for those assets. And then at your death, whoever's managing those assets is responsible to distribute those assets to your beneficiaries named in that account directly, so they don't have to go through probate and aren't subject to the probate fees and the delays and all that's associated with the probate process. So those are two really fairly straightforward, easy, and usually free ways to transfer assets after your death outside of the estate, outside of probate, in other words. There's one other main way to transfer assets outside of your estate, and that is by using a trust.
Okay.
So I was mentioning jointly holding property or naming beneficiaries. Well, you can't always do that, and it may not be advisable to jointly hold all assets.
Sure.
Specifically your house. Let's say your spouse is already deceased, and you don't want to transfer your property to your children, which we'll probably talk about a little bit later. That's not always advisable. So in order to keep your house out of probate, many times it's necessary to set up a revocable living trust or some type of trust. That's the most common that I recommend. So you set up the trust, and then you actually transfer the house into that trust. You're still in charge of that trust as trustee, but technically what that's doing is getting the real estate, the property, out of your sole name so that it doesn't go into your estate. It just passes directly per the terms of the trust after your death. And another nice advantage of that, of using a trust, aside from the probate savings, you save the time and the money, is the trust is not actually filed anywhere. So a will you file with the probate office, and that becomes public record. Yeah. But the trust is not filed, so the terms of that trust are generally confidential, and so
Okay.
you don't have to disclose exactly who gets what to the general public.
Okay. So like my cousins won't come after me when they see I own like, 10 portfolio, they won't,
Yeah,
all
that's
those
right.
aunts and uncles won't come out
Exactly
of there.
right. So that is a nice kind of side benefit. It's confidential.
Okay.
Now, I usually still recommend having a will in conjunction with that trust, even if we use the
Sure.
trust. The will is a short form will that is called, we call it a pour over will.
Okay.
The reason we call it the pour over will is because the metaphor, the idea here is that will instructs your trustee, or excuse me, instructs your executor to transfer your assets that aren't already in the trust to the trust. So in other words, the executor gathers up the assets and pours them over into the trust after your death. Now the problem there is those assets would still have to go through probate. So we really do want to set this up in advance
Yeah.
and transfer most, if not all, your assets into the trust prior to your death. But I still want to have a will in place just to kind of clean up anything that might be left behind, and to make sure you know who's going to be in charge of that by naming an executor.
Yeah. I mean, it makes a lot of sense. I
Yeah.
mean, so everybody knows where everything is going, and there is
Exactly.
no gray area.
And quite honestly, as far as cost goes, you're probably going to save your family potentially thousands of dollars by setting things up correctly in advance, because of the fees that are associated with probate, including a probate fee and attorney fees. Quite frankly, people wind up paying me at least the same amount or more to help probate the estate after the fact than they would pay me just to help set up the estate in the first place.
I just wanted to say thanks again for going through all this. Like I said, my name is Brandon Wyndham. I'm with Myers Realty. I'm here in Delaware, and we got Adam here again in Delaware. If you have any real estate related questions, feel free to reach out to me. If you have anything about estate planning or wills, probate, anything like that, Adam's your guy. And feel free to reach out, and we'll have all our info, either somewhere in the comments or in the description, so you can get a hold of both of us. And I hope you took a lot of value from this. And again, thanks again, Adam, for sitting down
Thanks for having me.
and talking down with us.